All right, it's 12:30, and I think it's about time to start our short webinar on Carriage of Goods by Sea and International Trade. By way of introduction, my name is Prem Gurbani, and I am one of the instructors in this course. You will also see on your screen Mr. Bernard Yee, my co-instructor, and Ms. Ko Si Bin, and another one of our co-instructors. The title of this course is Carriage of Goods by Sea and International Trade. The reason why we're having this webinar is to give you a little bit of information as to what this course is all about. And I'm glad that some of you have shown interest in this particular course, because the maritime sector is a hugely important sector of the economy in Singapore. For those of you who are unfamiliar with the magnitude of the sector, it constitutes a full 7% of the GDP in Singapore. To give you some idea of the operations that go on in Singapore, you can imagine that there are about more than 1,000 tons of cargo that are dealt with every minute in Singapore by the Singapore ports. 1,000 tons. There are 130,000 ships that call in Singapore every year. There are 5,000 companies involved in the maritime sector in one way or the other. And the sector employs, on 2018 figures, and which may well be higher now, more than 170,000 people. So you would imagine that's quite a sizable chunk of the Singapore economy. How is it relevant to you as aspiring lawyers? Well, a large sector of the economy means that inevitably you will come across some of the issues that are dealt with in this course, which principally deals with international trade, but which requires that you deal with contracts of carriage, maritime law, in order to understand international trade. So the course itself is going to be divided into two broad sections. The first section being maritime law, which is a consideration of contracts of carriage in maritime law largely. And then after you have built a foundation in maritime law and contracts of carriage, then you can better understand what international trade is, because without a short understanding of maritime law, you will not be able to appreciate some of the issues that arise in international trade. Now, by way of housekeeping matters, you will see on the screen, today's session is scheduled to last for about 30 minutes. Just after me, Mr. Yee will give you a short introduction on his part of maritime law, which will be bills of lading. That will take about 5 minutes. And that will be followed by Si Bin, who will say something about charter parties. Then she will also take 5 minutes. And then the ball will be returned to me, and I will tell you a bit as to what international trade, the international trade section is all about. I will join the instruction after the 6th week. For the first 3 weeks, Mr. Yee will be with you on bills of lading. For the second 3 weeks, it will be Si Bin, dealing with charter parties. And after you have built your base, as I say, then I will join from the 7th week onwards to deal with international trade. It will be a total of 12 weeks, with 1 week left for revision. Right. So the other thing, as far as housekeeping is concerned, please submit your questions by using the Q&A button at the function bar. Please feel free to ask whatever is in your mind. We will do our best to answer. And even if we can't answer every question live, we will certainly return to you in writing at a later time. Or if you can see there's a QR code there. You can write in using that QR and submit your question, and we'll certainly come back to you. Now, with that, I will pass to Bernard.
Hi, good afternoon, everyone. Just to add to the figures that Prem mentioned, in 2021, Singapore again was ranked as the busiest transshipment port in the world. A total of 37.5 million containers passed through our ports in 2021. And what that means is that just containers alone, right, you could possibly have 37.5 million bills of lading issued for each container that is shipped on the vessel. Well, of course, sometimes the bills of lading can refer to more than one container in each document. So you will then appreciate how important this document, known as the bill of lading, is to shipping. Some have described this document as the key to the warehouse. So in our course, in my section, you will learn, as you see on the screen, an introduction to the various documents for the carriage of goods by sea, including bills of lading, which will be the key document that we will be dealing with. An overview of it. You learn about who the parties are in the bill of lading, and we will even deal slightly, quite briefly, about electronic bills of lading. So nowadays, everything is going paperless. I mean, the shipping industry is no exception. They're trying to make shipping documents paperless as well. Then we will go on to learn about the functions of a bill of lading. Bill of lading is actually quite a fascinating document, right? Usually no more than, usually no more than 2 pages, the front and the reverse. But this piece of paper is a multifaceted document. It performs different functions, just a single piece of paper. You'll learn what they are. And then we will also learn about other documents related to a bill of lading, in particular, letters of indemnity, why they are necessary, what are the risks of accepting a letter of indemnity, And in the last part of my segment, we will deal with the international aspect of the carriage of goods by sea. In particular, dealing with the Hague-Visby rules. Shipping, because of its international nature, the rules that and then the laws that govern the contract of carriage are not limited to only those that are promulgated in Singapore, but they are conventions, they are international rules which also apply to carriage. So we will learn about those as well. That gives us the international flavor of shipping. So over the 3 weeks, we will cover all these, and that is to give you some sort of grounding for you to then move on to the second part of the course, where you learn about charter parties. Right. That's all I have. Sibin, you.
Yes, Sibin.
Hi, my name is Sibin, and I'll be touching on the topic of charter parties. As we'll hear from Bernard's introduction, basically bills of lading deals with rights and obligations in relation to the cargo. So charter parties basically deal with the rights and obligations of parties in relation to the use of a vessel. Throughout the course, what we'll touch on are the types of charter parties. Briefly, the key two types are the voyage charters and the time charters. The focus will be on the key obligations that a ship owner or a charterer will have under the voyage or the time charter. Now, just to give you an example, you will be aware of the Russian-Ukraine conflict. One issue that arises has been whether a particular cargo can be shipped from a particular port out of Russia, for example, for carriage to another port in Asia. So that calls into various issues under the charter party, right? So for example, is it an excluded cargo? Is it a lawful cargo? Possible questions relating to sanctions. And as the ship owner, the issue to be decided on would be whether you are bound to comply with your charterer's order. So that is an illustration of how closely tied to the economy, the charter parties and bills of lading disputes can be. Another instance would be, for example, you might have your seller of the cargo declaring a force majeure because, for example, in Indonesia, the government has an export ban on palm oil, and now your seller cannot ship those cargo, and there's some force majeure argument. And your ship has been chartered and you're sailing towards the load port and you want to know what can you do now. So that's another example of the kind of issues that may arise in the charter party context. I think that's briefly what I have in terms of a very general introduction on the topic. Maybe I'll pass it over to Prem for the next section.
Right. Thank you very much, Bernard and Sibin. Now, I did say earlier that the foundation for international trade has to be maritime law, as far as that section of maritime law that relates to contracts of carriage and charter parties is concerned. The understanding of these concepts is extremely important because in international trade, these documents, especially, I say, bills of lading, are integral in passing property, in determining risk, and so forth. So you will have to learn and understand and master the concepts in relating to bills of lading and charter parties before dealing with international trade. But when you do eventually get to international trade, in the 6 weeks that you will be with me, you will have the opportunity of considering the common types of contracts that are used in international trades. For instance, you may know what a CIF contract is. You may know what an FOB contract is. And these are the two principal contracts that are used in international trade. And we will examine the more common contracts to determine what the incidents are and how they help to define the obligations and rights of the parties. We will also deal with the methods that are used in international trade for payment, such as cash against documents or letters of credit. We will understand how a letter of credit works. Excuse me. What is necessary to tender under a letter of credit, and you will have a clear understanding of how the UCP 600, which is the code that relates to letter of credits, helps in international trade. Now, by way of a remark, if you have an understanding of payments, how payments work in international trade, then that will also help you in non-maritime areas, because letters of credit are universally accepted in many other areas which do not involve trade. They may well involve other areas, even construction, even the standby letters of credit, for instance, which are governed by certain of these documents, which we will deal with. We will deal with those documents, but the principles will apply not only to maritime law, but generally across all laws where it is intended that there be a secure source of payment, right? We will deal with remedies in international trade. What happens when there is a breach of contract? What sort of remedies are available? How do you obtain these remedies, right? And most of all, because the three of us are all, in a sense, practitioners, right? We will help you to try and solve problems that you read about. The end result must be that you can look at a problem and deal with it and solve it, applying what you have learned over the 12 weeks. What am I talking about? So, well, let's give you an example. The Ukrainian war breaks out, the Ukrainian conflict breaks out. A ship is loading cargo, it has to stop loading. It cannot leave because Ukrainian ports are mined. So there's some cargo on board, there's some cargo on the wharf and berth, which cannot be loaded. So where exactly are the rights and obligations, right, of the parties? What are the rights and obligations of the ship owners in this situation? What are the rights and obligations of the charterers? What are the rights and obligations of the seller who has got half of his cargo on board? And what are the rights and obligations of the buyer? So these are situations that you read about, but which we will help you analyze and solve. Similarly, you recently might have read in newspapers that Indonesia banned the export of palm products for about 4 weeks until there was extreme political pressure, and that ban was lifted. So what happens when a ship is heading towards the port of loading and the ban comes into effect? What is the right of the ship owner? What's the right of the charterer? What is the right of the seller, the buyer? And what happens when the ban is finally lifted? Are those outstanding contracts to be performed, or were they terminated by the ban, or was it, or were the rights of the parties merely suspended? So these are the sorts of situations which we will be dealing with, and eventually you will be asked to solve in order to understand exactly what goes on every day. I mean, last year we had situations like where, that giant container ship blocked the Suez Canal, right? So what were the rights and obligations of the parties? The cargo owners on board, the ship, the charterers. So that's what we're looking for. We're looking to give you an understanding of the real world effects of real world events. And I hope you will join us in a journey of discovery in that respect. I should also mention that at the end of the course, the best student, of course, get a prize from the Singapore Maritime Foundation, which is sponsoring this particular webinar. Right, so I think we have reached about 12:50. What we should be doing now is to try and see whether there are any questions which we can help answer. I can see one question by an anonymous attendee, which asks, how does this course compare with Other courses indicated as being mutually exclusive. 423, Law 423, Maritime and Admiralty Law in International Commerce. Well, to be honest, I do not have the course content for 423 or 443 before me, so I can't tell you for sure. But one thing I can say is that Admiralty Law is not part of the curriculum here. The whole purpose of this particular course that we are dealing with is international trade. And the study of maritime law is towards understanding international trade, rather than maritime law proper in itself as a subject. And Admiralty law, which is largely procedural, is not part of this course. It may well be another part of another course in the SMU. I don't know. I can't say for sure. Now, 443, again, I do not have the course content of it, but the fact that it is mutually exclusive means that it's probably meant to deal with international aspects or international regulatory aspects on a country-to-country basis. But I can't tell you for sure. Please look up the content of the course and determine exactly what is being taught there. That's the best answer that I can give you. There's another question here. Will this course be available next academic year? Well, we started this course last year, right? And we're going to continue this year. And if all goes well, yes, we will continue next year. But that well depends on whether we have a core of students that is interested in pursuing an interest in this particular subject. We hope there is, because I can't imagine that you will get through legal practice without somehow needing what you have learned in this course, unless you're going to be a consumer lawyer. A consumer lawyer meaning family law, criminal law, debt collection, that kind of thing. Then you probably won't see anything of this. But if you are in a regular international firm or a firm that deals with international aspects, you will surely need some aspects of this course. Yes, we hope this course will be available next year. And we're optimistic that we will be. If yes, can the course for the next AY have a final graded component as a research assignment? Now, as the course is now run, we have a 20% participation component. We have a 30% research assignment for the bill of lading and maritime component, right? But we have a final component of 50% as a final exam. We feel that is important, and we want to try and maintain that final component of 50% as a final exam. How willing and able are you to accommodate students who want to do this on audit? Well, Sebin, Bernard will correct me if I'm wrong, but I think we had one audit student last year, right, from the Attorney General's chambers.
Yeah,
Yeah.
we did.
We did, yeah. So yes, the answer is yes. We accommodate audit students. With the faculty will usually ask us, and our answer is no problem at all, right? Are there, okay, good question. Are there many opportunities for maritime lawyers in Singapore? I think there are more opportunities than there are applicants, right? After 4.5 decades in practice, I am no longer in active practice. Most of the time I'm a mediator and counsel, although I still have my practicing certificate. But people like Bernard who run law firms will tell you that there are many opportunities for maritime lawyers in Singapore. Okay, let me add this. Let's see whether Bernard and Sebin agree, right? If you can do shipping law you can do any other type of law, but you have not done shipping law, right? You cannot do it. So it's best that you do shipping law so that it opens you up to any other kind of law. By the way, most of the principles that come into contract law, for instance, actually originate from shipping law cases, right? Your Swiss Atlantic, right? And all sorts of other cases that relate to frustration, Hong Kong fur. And so those things that are part of your contract courses, which are compulsory before you can come into this course, they are principles derived from shipping law cases. Ragged Mound and so forth, and all principles that derive from shipping law cases. Right. Will a practitioner of shipping law have to study all of the areas discussed earlier? No. If you intend to practice in the area of international trade, you do not have to take Admiralty law. Right? You do not have to take Admiralty law. It is good if you do, if you want to, but Admiralty law is actually offered as an optional in your part. What part is it? B?
B.
Part B. When you want to get admitted to the bar. So you can take Admiralty law at that part, you know, you can just put it off to the end and take it as an optional when you do your part B. Or you can take it now if it is offered by the SMU separately. But seeing that we only have 12 weeks, there's no way we can deal with Admiralty law unless it's going to be extended to a full 24. That's a different thing. But your question is simply answered as shipping law. If you say, will a practitioner of shipping law, if you say, yes, I'm a shipping lawyer, then I suppose you should say that you know some aspect of everything. But if you're just going to do international trade and contracts of carriage, then you don't need Admiralty law. If there's any follow-up to the question, you want to ask any follow-up questions, please go ahead. How do I improve my chances of receiving a training contract as a maritime lawyer? Bernard, I give that to you. Yeah.
You know, I think that the fact that you have done a shipping course in either SMU or NUS, right, sort of puts you at the top of the pile of applicants, right? When we are hiring, when we are looking to hire a shipping lawyer, we quite oftentimes the situation we face is that the applicants that we have no shipping law background in school, right? But nonetheless, it doesn't stop us from taking such a candidate because shipping law can be picked up along the way as well, right? But like I said, if you already have done shipping law in school, you know, your application will be at the top of the pile.
Yeah. Okay. And I may just add there that the SMF has actually got a facility where you can write to the SMF. We have a register of firms that want to offer training contracts in shipping law. And you can actually write to the SMF for help to get a training contract, and we'll try and match you. All right. Can we audit this course even though our bidding is unsuccessful? It is ALR. What does that mean?
Already successful.
Already successful.
I suspect this is a question that's best answered by the faculty.
Correct, yes.
We're probably not in a position to tell you that.
Yeah. So that's something you are going to ask the faculty, and the faculty is extremely helpful, and they will give you a quick answer. Following on from the question regarding opportunities for maritime lawyers in Singapore, how does it work when so many contracts are governed by English law, New York law, and so forth? Well, when you say you study shipping law in Singapore, of course you do study shipping cases, Singapore shipping cases, but the large part of your education is actually English law. It's the same when you do contract law, isn't it? So it's the same when you do tort, isn't it? So you will have to study English law when you study carriage of goods by sea as your for this course, or international trade for this course. And your knowledge of these areas will be relevant no matter where you work. And you will see that there are lots and lots of international firms in Singapore, in Hong Kong, in New York, and elsewhere who hire graduates that have done all the commercial subjects in a Singapore faculty, law faculty, which is either SMU or NUS, right? So yes, it will hold you in good stead. In good stead. Is this course useful for a career in international arbitration? I would say yes, because I'm a living example, right? I am now an international arbitrator. I don't just do shipping law. Now my work involves all sorts of things, construction, joint venture contracts, and so forth. But because I've had the opportunity to deal with all sorts of complex shipping cases in the past, that's held me in tremendous stead going forward in a career in international arbitration. So the other thing that you will want to note, as Sebin will tell you, almost every shipping law case is the subject of an arbitration rather than court proceedings. Very few shipping law cases go to the Singapore High Court, right? Only a small portion. The rest of it is all in arbitration. So if you're going to do, if you're going to be practicing in shipping law, international trade, carriage of goods by sea, 8 out of 10 cases will be dealt with by international arbitration. I hope that answers the question. Right, so it is now 1:02. Any other questions? Please feel free to ask. Let me see, anything else here? Right, so if there are no further questions, thank you very much for attending, and I hope that all of you will be with us when we start the course, I think in the middle of July, right?
August.
Middle of August, I'm so sorry. Yeah. And hope to see all of you, all 10 of you, and more.
Tell your friends about it.
Yeah. Thank you very much. And
Okay.
Thank you.